Good evening, everyone. My name is Kuzumi M. Prospero, and I will be reporting Section 3, which is the special provisions for leases of rural lands. Rural lands is defined as a product producing lands, regardless of site. If the principal purpose is to obtain products from the soil, the lease is of rural lands. Article 1680 states that the lessee shall have no right to a reduction of the rent on account of the sterility of the land leased or by reason of the loss of fruits due to ordinary fortuitous events, but he shall have such right in case of the loss of more than one half of the fruits through extraordinary and unforeseen fortuitous events, save always when there is specific stipulation to the contrary. Extraordinary fortuitous events are understood to be fire, war, pestilence, unusual flood, locust, earthquake, or others which are uncommon, and which the contracting parties could not have reasonably foreseen. Introduction of rent in rural leases. In terms of application, Article 1680 is a special provision for leases of rural lands, so it cannot be applied analogously to ordinary leases, or precisely because of its special character. It was meant to apply only to a special species of lease. The lessee is entitled to reduction of rent if the following requisites are present. First is that the land lease is rural. Second, more than one half of the fruits have been lost. Third, the loss occurred through extraordinary and unforeseen fortuitous event. And last, there is no specific stipulation that the lessee is nevertheless not entitled to reduction. There are cases that do not justify reduction. The lessee is not entitled to reduction of rent in the following cases: on account of the sterility of the land leased, by reason of the loss of the fruits due to ordinary fortuitous events, regardless of the extent of the loss, by reason of the loss of less than one half of the fruits, even though extraordinary and unforeseen events, by reason of the loss of the fruits through extraordinary but foreseen events, regardless of the extent of the loss, by reason of the loss of more than one half of the fruits through extraordinary and unforeseen events, where there is a specific stipulation to the contrary, and where the loss of the fruits occurred after they have already been gathered, regardless of the extent of the loss. The effect of sterility of land in case of rural lease is there is no reduction of rent. The reason is that the fertility or sterility of land has already been considered in the fixing of the rent. The effect of loss due to a fortuitous event. In terms of ordinary fortuitous event, there is no reduction of rent. The lessee, being the owner of the crops, must bear the loss. This is in accordance with the maxim res credit domino. And when it is an extraordinary fortuitous event, as a general rule, if more than one half the fruits were lost, there is a reduction of rent. Exception is if there is a specific stipulation to the contrary. If less than one half, or if the loss is exactly one half, there is no reduction. Extraordinary fortuitous events are those with our fire, war, pestilence, unusual flood, locust, earthquake, and uncommon things which cannot reasonably be foreseen, like armed robbery. Article 1681 states that neither does the lessee have any right to a reduction of the rent if the fruits are lost after they have been separated from their stalk, root, or trunk. Note that the reduction referred to in the preceding article can be availed of only if the loss occurs before the crops are separated from their stalk, root, or trunk. If the loss is afterwards, there is no reduction of rent. Article 1682, the list of a piece of rural land when its duration has not been fixed is understood to have been made for all the time necessary for the gathering of the fruits, which the whole state lease may yield in 1 year, or which it may yield once, although 2 or more years may have to elapse for the purpose. Duration of rural lease. Number 1, the duration is not fixed in the contract of lease between the parties, or in the absence of the stipulation. The duration is fixed by law, to wit, the time necessary to gather the fruits which ordinarily would come 1 year in case of agricultural crops, or more than 1 year in case the land may yield only once and 2 or more years may have to elapse for the purpose. Case problems number 1. How long is a rural lease with an unspecified duration if it takes only 3 months to plant and harvest the crops, and therefore 4 harvests can be made in 1 year? The answer is 1 year. This is in accordance with the first part of Article 682. Number 2, how long is a rural lease of unspecified duration if to plant and harvest crops once will take 3 years? The answer is 3 years in accordance with the last part of the Article 1682. Article 1683 states that the outgoing lessee shall allow the incoming lessor the use of the premises and other means necessary for the preparatory labor for the following year. And reciprocally, the incoming lessee or the lessor is under obligation to permit the outgoing lessee to do whatever may be necessary for the gathering or harvesting and utilization of the fruits, all in accordance with the custom of the place. Obligation of outgoing or incoming lessee or lessor. Number 1, the outgoing lessee shall allow the incoming lessee or lessor to make the necessary work preparatory for the crop the following year. And number 2, the incoming lessee and lessor shall permit the outgoing lessee to gather or harvest and utilize the fruits he has produced. Article 1684 and 1685. Article 1684 states that land tenancy on shares shall be governed by the special laws, the stipulations of the parties, the provisions on the partnership, and by customs of the place. Article 1685 states that the tenant on shares cannot be ejected except in cases specified by law. Rules governing tenancy shares. Land tenancy in shares is primarily governed by special laws like the Agricultural Tenancy Act or RA 1199, and suppletorily by stipulations of the parties, provisions on partnership, and customs of the place. Extinguishment of leasehold relation. The following are the causes or modes by which the agricultural leasehold relation may be extinguished. Number 1, abandonment of the land holding without the knowledge of the lessor. Number 2, voluntary surrender of the land holding by the lessee, written notice of which shall be served 3 months in advance. Number 3, absence of a successor or heir in the event of death or permanent incapacity, such as total blindness, insanity of the lessee. This is in accordance with Section 8, RA number 3844, as amended by RA number 6339. Number 4, termination of the leasehold by the lessee under Section 28. Number 5, acquisition of the land in question by the lessee. 6, mutual consent of the parties. And lastly, judicial ejectment of the lessee under Section 36. There are causes for dispossession of leasehold tenant are the following. Number 1, declaration of the suitability for non-agricultural purposes, like for example, declaration of the land holding by the Department of Agrarian Reform, now called land reform, to be suited for residential, commercial, industrial, or some other urban purposes. Number 2, non-compliance with obligations. So failure of the lessee to substantially comply with his contractual and legal obligations except if caused by a fortuitous event. Number 3, use of land contrary to stipulations, like planting crops or using the land holdings for a purpose other than what had been previously agreed upon. Number 4, non-adoption of proven farm practices. So failure of the lessee to adopt proven farm practices. Wrongful injury to land, such as substantial damage or destruction or unreasonable deterioration of the land or other substantial improvements thereon through the fault or negligence of the lessee. Number 6 is non-payment of rental. So failure of the lessee to pay the lease rental. And number 7 is employment of sub-lessee. Employing a sub-lessee is that if the lessee is ill or temporarily incapacitated. That's all. Thank you.